Hello, everyone. Welcome to a special Patreon one-on-one interview. You may have read the reports last week of a landmark lawsuit involving an order from a federal judge in Ohio to pay three pharmaceutical chains, CVS, Walgreens, and Walmart, a heck of a lot of money, some 650 million, just for their contribution to the opioid crisis in two counties in Ohio. I was trying to calculate what that would mean if you played it out nationally. We've just done, as you know, this week a special episode on the overdose crisis, especially with fentanyl. So this is a very integral part of that, and we're really fortunate to have to discuss it all today Jan Hoffman, who wrote the piece in the New York Times and has been in the Times for some 30 years and covers now behavioral health and health law. Has won many awards, including the Mike Berger Award, Newswomen's Club of New York Award, American Bar Association Silver Gavel Award, though she hastens to add she's not a lawyer, even though there are many in her family. So this will not be a legally intensive discussion, nor need it be. Jan, thanks so much for being here.
My pleasure.
Okay, so you don't have to give us the actual legal ins and outs, but just the basic notion of how it came to be that who sued and what they were saying in lay person's terms that resulted in this order last week for such what seems a colossal amount of money when it's only for part of the damage in two Ohio counties.
Okay, I'm taking a deep breath. Only because, as they say, it's complicated. And
I was on Deadline last week, and Jan Hoffman was the guest, and he started out with Namaste. So okay, here we Namaste. All right, we're ready.
All right. This trial is known as a bellwether. That means in this instance, there are thousands of opioid cases across the country, but there have been a few sample cases selected to basically try out the arguments on both sides to see how they fare. One of the many difficulties in the opioid litigation is that there are so many different kinds of actors. So how do you prove who's responsible for the devastation ongoing that we're seeing? The cases essentially break out into people who make the drugs, known as the manufacturers, people who deliver the drugs to the pharmacies, known as the distributors, and the pharmacies themselves. Certainly one can argue that there are other actors, but they're not involved in this litigation. The first two groups have had a lot more settlements. That would be the manufacturers and the drug distributors. The three big drug distributors, in fact, have had a national settlement.
So they've written a check and they're out, basically. Is that too legal? Sorry.
They have to pay out over something like 18 years. So they're writing little checks. They would say they're big checks, but they're little checks. And they're starting to send them out. The group that has dragged its feet the longest has been the pharmacies, because they have always argued, hey, we are giving out prescriptions that are sent to us by doctors of medications that are approved by the government. How is this possibly our fault? And that's a completely legitimate question. We are just doing our job, they say. The plaintiffs, who have been state governments, cities, counties, Native American tribes, and A small handful of
But public entities, not individual patients for the most
No, I
part.
was just about to say there is a
Oh, I'm
small
sorry.
group
Yeah.
of individual plaintiffs, but we can put them aside because they've got the steepest mountain to climb, and it's unclear that they're going to be able to climb it. But in this case, we're looking at two public entities, counties in Ohio, who have been chosen to test out the arguments on both sides by the judge, who is Judge Polster, who is basically coordinating thousands of trials across the country. Thousands of cases, not trials. In this case, this was the first time that the pharmacies themselves faced a jury. It was a two-part trial. The jury only had to determine whether it thought the pharmacy companies were liable for any or all of what they call the ongoing opioid epidemic. Once the jury said yes, then the trial went to a second phase just before Judge Polster to determine what is the cost going to be. And so this is what the ruling represents. His jury, the judge sat over the trial itself. The jury said back in November, yes, they are liable. And now, after the second phase, the judge says, and this is what it's going to cost you.
All right. And I can imagine, given the enormity of the problem, that even in two counties or whatever, that you could reach that price level. But it is truly eye-popping when you think of this as bellwether trials applied broadly. Let me double back though for a second to
Well, yeah, just
so
remember about what this really, then we have to unpack what it really means. I mean, whether there's
yeah,
actually going to be a check written for 650 million is another question.
fair enough. Yes. All right, but just to double back, you did lay out a pretty what seems like a sensible argument by the pharmacies. What was the winning argument by I guess the county governments here in response that swayed the jury?
Let me say one thing about this particular trial.
Sure.
Um, for any of your, excuse me, viewers who are, I shouldn't say law junkies, particularly in this context, um, um,
Okay.
who follow the law and trials
Right.
as major super fans.
Who just inhale it, just swallow the. No, I'm sorry. Go ahead. Yeah.
So the lead trial lawyer for this case is a lawyer named Mark Lanier. And
Right.
maybe 6 of you out there will go like, "Oh my God, they had Mark Lanier, no wonder." Mark Lanier is arguably maybe one of the top 5 trial lawyers in the country, and he has made a brilliant career of winning against pharma. He is ostensibly folksy. He's smart as hell. He uses lots of wonderful metaphors and images to convey his story. And I read his closing and opening arguments. I've spoken to him many times, and I would be hard pressed to find a jury who would deny Mark Lanier when Mark Lanier says something. So let's just say that, because there have been other cases that the pharmacies have fared far better than this one, and they have been before judges. So essentially, the pushback against the pharmacies saying, but we're just handing pills that were prescribed to us by doctors, goes as follows. You have a due diligence obligation to be watching out for red flag warnings, to be noticing when a patient is coming more than once a month to fill a monthly prescription, to be noticing when a patient is taking egregious quantities of this same very dangerous and potentially also very helpful medication. You have obligations to report, to call the doctor, to call the drug distributor. You have all kinds of affirmative obligations to do what is considered to be your very special job. And you, pharmacies, the plaintiff said, didn't do it. You look the other way.
And was the argument further that it was kind of corporate policy from on high, Walgreens, CVS, not just individual pharmacists in individual
Absolutely.
places, but yeah,
Absolutely. I mean, that's how they got to the deep pockets.
yeah, and and the theory is there's really a lot of money. So I don't know about the level of prescribed um, opioids. By the way, what are we talking about? More? What are we talking about? OxyContin, and what are the opioids in question here?
Oh my goodness. There are so many.
Many?
Oh, there
I
are
see.
many.
Okay.
There are many.
Um,
But remember too that over the 20 years that this has been unfolding, many of the name brands have gone into generics.
yes,
So
right.
it's a vast market, or was a vast market, no longer is.
Maybe we'll get into that in a moment. But so, is the basic notion this, that they say the pharmacies, look, there are these bad pill docs out there who will write prescriptions for anyone, and the plaintiffs say, yeah, that happens, but you're part and parcel of the problem. They couldn't make it. So it's basically the combination of um, indiscriminating or maybe even criminal people with medical degrees who'll write it out for anyone, but they couldn't. But it could only be effectuated through the pharmacies. That's the basic idea.
Exactly.
Okay, so now back to Polster, the judge, and the price tag. Let's talk about then why you say it doesn't necessarily augur a check of anything like this magnitude. And I'm right, yes, that it's just this amount, the 350 million, is just for those two counties. So as a bellwether trial, it would be multiplied several fold. But you don't see the tangible prospect yet of a serious womping like that. Why not, and what has to happen?
Okay. First of all, let me clarify. It's 650 million from three
Right.
big
So
corporations to two counties over 15 years. To reach, you know, that number, in the second phase of the trial, the plaintiffs had to say, this is what the opioid epidemic has cost us, but more importantly, under their legal theory, it's an ongoing nuisance. That's the term of art. It's hardly a nuisance, it's a horror. And it is your obligation to help us. And again, the legal term is it's not damages, it's called abatement. You have to help us abate this nuisance. And so they presented through a series of experts what that cost would be like for 15 years, what it already has been, and what it's going to be. As Mark Lanier said to me at one point, he said, well, we asked for the sun, the moon, the stars, and the judge gave us the moon. And I'm pretty happy with that. Remember, you have to discount for what the distributors are going to have to pay and what the manufacturers are going to have to pay.
oh, is that right? So
That's
that's just all right. So that's a
yeah.
big point. Okay.
Their big ask, their total ask was 3.3 billion for two
Hmm.
counties. Now, realistically speaking, first what's going to happen is the pharmacies have already filed an appeal of the jury trial. So they're going to argue that the jury trial was reached the wrong verdict. Then we have to question whether that's going to be upheld. That's going to go to the Sixth Circuit Court of Appeals. There'll be more firestorms. That's going to take a long time. At some point, it could even reach the Supreme Court, whichever, because this is such important litigation that is nationwide and raises the use of this controversial legal theory, which is public nuisance. The court may have to ultimately weigh in about whether this is a legitimate use of that legal theory. So in the meantime, the plaintiffs are going to go to the defendants and say, hey, look, you have years of litigation ahead of you. You have
Right.
another finding against Walgreens by a federal judge in San Francisco. You have two more pharmacy trials coming up in September in federal court. You want to sit down and talk real dollars and cents? So that's what's going to be
Yes, I
going.
certainly see. Yeah, some of the work I do in my own legal practice has something of that dynamic, and the plaintiffs are always looking to settle sooner. And for the defendants, $1 million a month is what they're paying in legal fees, and that's less than the interest on this kind of verdict. So maybe they just keep rolling the dice.
Well,
Well, how does go
I
ahead?
just want to say, Lanier himself was, maybe this is inappropriate, that's not for me to say.
Yeah.
He was chuckling and he said, when we were sitting down, we were trying to get them to negotiate, and they could have settled for a lot less than this. And it
Yeah.
becomes, as many people say, a cautionary tale in the cost of going to trial versus getting it done up front.
Yeah. Do we know generally just sort of what percentage of the nationwide problem for which this was a bellwether these two counties in Ohio are? Is there yeah.
It's a really good question and almost impossible to answer. But let me try to explain why, because I really respect the question. Um, it took the plaintiff lawyers, and there are troops and troops and troops of lawyers on this in this litigation over a year, not only to cull all the data from the CDC and the DEA to figure out how many pills were being distributed in which counties in America, and versus what the population was, how many overdose cases there were, and then how many deaths there were. I mean, it's an incredible, and there's a live map that they're working on to figure out apportionment. So it's extraordinarily complicated, although you can punch in the numbers and figure out from any settlement what tiny percentage your county is owed. These two counties were definitely hard hit. There's no question about it. Were they as hard hit as Cabell County in West Virginia, which is often
Yeah.
described as ground zero? That's not for me to say.
I see the issue. Well, at the end of the day, if they, and I agree with you, the odds of this are remote, but if everything is litigated out and they're just, you have a series of determinations, is there some grand poobah that's going to actually say, here is your total price tag, CVS, Walgreens, and and here's what you have to pay totally, and if and when that happens, is uh, the whole question of their contribution to the crisis settled and closed, or is this something that's probably plays out in more and different trials and kind of indefinitely as long as there are opioid drugs being prescribed?
So are you asking me,
I didn't. Let
is
me
there
just say
an
that I didn't put that very well. Um, Eventually, somebody's gonna do a final. I'm thinking about this and this overall structure, and this is just two counties. This is driving towards some kind of final resolution of CVS, Walgreens, and Walmart's liability for all the cases as of 2022. Is that right? And if it came to it, who would make that final determination? Is there one judge who's, on Mount Olympus whose role this would be?
Well, yes and no. Um, and I really have to emphasize enough, it's my own liability waiver. I'm not a lawyer.
Yeah. Right. Sign. Wait, I think it says here. Oh, yeah, you're right. Okay, go ahead.
I was an English
All right.
major.
Okay.
Um,
Me too. Me too. Yeah. All right.
um, my understanding, she said, bulletproofing her
Yeah.
answer, is that if the parties themselves can come up with an agreement, it goes before Judge Polster to bless and approve it.
Ah, okay. For nation, so Polster
Yes.
is, well, he's talking about these two little counties. He's involved very broadly.
Yes.
We've
Yeah, he is, okay, you can do a face plant. get ready. The more than 3,000 cases in this litigation so far are what is known as multi-district litigation. It's
Right.
all over the country, and Judge Pulser was 4 or 5 years ago assigned for him to be basically the ringmaster.
He's okay. So I do understand that role, and this is sort of similar. I mean, well, let me ask you. I don't know if you had occasion in your beat to cover it, but we've been through this kind of big state or locality driven litigation before with cigarettes. I know we've been through it
What
with banks,
very
which is a
different.
little
This
different.
is not
But
like
but I don't remember this idea of a nuisance. So is this really cutting edge?
okay. You threw a little bit of a fireball in there, and I just want to clarify that before I answer your second, also very good question. People have rushed to compare this to the tobacco litigation.
Yeah.
And they are more different than they are similar. And that's where people get tripped up. And I don't want to walk you down way far down that road, but
That's really yeah. Suffice to say, if that's what you're thinking, put that to the side.
but I want to carefully, and I want to make
yeah.
two somewhat quick points. Tobacco, because of the way it was structured, is, because it still is bringing in money,
Right.
brought in a lot more money than the opioid litigation ever will, which is rather heartbreaking, but true. And one of the many big differences procedurally between the tobacco litigation and the opioid litigation is tobacco was against 5 or 6 different companies. That's it. They did everything soup to nuts. And at that point, the FDA was not overseeing tobacco. So you lost the defense of having government sanctioned materials, and you didn't have dozens and dozens of companies. You just had 5 or 6. So, and also it never really got to the legal stage that the opioids are. So that's huge structurally why you can't go there. The other important point I wanted to make, because you raised it earlier, and I feel this very strongly, and I haven't seen your work that you've done on the drug crisis in general and fentanyl, but it's something I do write about, is this is being led by public entities, as I've said before, governments. And they are building on the backs of individuals and families who have suffered terribly. Those individuals and families, for the most part, will not benefit from this litigation.
Right. No, I mean what they're being asked. The companies are being asked to reimburse the counties for all the public outlay. Right. That's what this one is about. Yeah. And there's no, as far as you know, commensurate or even much smaller effort to compensate individuals.
There are a few very small ones, and there is like chump change built into the Purdue settlement if that ever gets realized.
Yeah.
And there was a case that was supposed to go to trial representing some individuals in Georgia, but that got set aside. Basically, babies born with neonatal abstinence syndrome, as a result of their mothers having an addiction to opioids. But relatively speaking, compared to the rest of this, almost none.
But I believe you said, did I understand correctly that you think we're sort of, we have to compensate, and there's all kinds of tragedies behind us, but that this has now become much less of a current modern problem in 2022, at least as far as pharmacies are concerned. Is that correct? And if so, why?
I can answer that question. Do you want me to go into public nuisance first, or you want me to go right to this? Because it's
Whatever
really
is
good
most
questions.
germane for the listener. Yeah, I mean, we're really privileged to have your knowledge here. Bring it however you make sense. But no law.
I don't do law.
Exactly. No law, no windows. Okay.
No, me. No, not me.
Okay.
Okay. I won't do law, so let me tell you why about public nuisance law. All right.
Great.
I'll try to be succinct. Public nuisance law was, and I also may misspeak, so forgive me, is, I believe, dates to the 12th century England and is a property concept. The idea was, if you were doing something that created a nuisance on the king's property, you had to abate or change your behavior. It's really old law, and every state has its own version of it. Who pays, blah, blah, blah. So it's expanded from, pretty minor scuffles to major environmental pollution cases.
Right.
Lead paint. It has made huge inroads, although not straightforward in that area. The question is, can you apply it to public health? That's what this litigation is really all about. Have you created a public nuisance such that you must help correct it and change your behavior? Speaking of that, by the way, there is an important part of Judge Polster's opinion, as there are in a couple of the others, which has requirements on the companies to change some of their business practices, which is essential for abating the public nuisance. It's not just money. It's how do we make sure you're not going to do this again? Remember, too, that in exchange for these massive national settlements, such as the drug distributors have made, they are asking for something known as global peace, which is a term of art, which means we pay you this money, you got to guarantee us we ain't going to be sued again. We're done. We're out of here. So I hope that answers your question about the novelty of public nuisance. It's kind of yes, no, sort of maybe.
Mm-hmm.
It
does, and I'll insert a little bit of law to just say, it is a tort concept, and if you, I don't know, have a slide that's broken or has a sticking up nail, and people would sort of, it's a nuisance on the public property or whatever, and that, yeah, so it is a novel theory for here.
Okay, now the pharmacies.
But then second, what I was most interested in, my sense is the practical problem from bad behavior by the big pharmacies you suggested is now has reached a different point where it itself is much reduced. Is that correct? And why? So are we mainly looking to remediate backwards, or are we anticipating because the overall opioid crisis is as bad as ever,
worse.
right? Last year,
it's worse.
we were over 100,000. Yeah. So
it's
go ahead.
Worse. So, if you see a causal relationship, and most thinkers do, we were essentially, and I'm sorry, since I haven't seen the first part of this program, I don't know if I'm repeating what you already have said. We're essentially in the third wave of the current opioid epidemic, which began with prescription painkillers in the late 1990s through, at least through 2016. Those pills got diverted, and all kinds of crime happened. The pills became harder and harder to find for lots of different reasons. People turned to heroin, which was cheaper. And now they have turned to fentanyl, which is not only cheaper than heroin, but far more ubiquitous and easier to access. So what triggered it? What triggered where we are now? One can absolutely argue that it started with the opioid crisis. And that's what the plaintiffs are essentially saying, is that where we are now with overdoses, with broken families, with loss of wages, with children being raised in very difficult situations, and a sort of now generational history of drug use begins with you and your bad acts. So you have to
But
fix this.
I see that, but I thought you suggested that practices on the ground, either the legal regime or what people are doing, have changed such that we're not having the same degree of the crisis emanating from the practices of pharmacies
Okay,
now. Is that
let me
correct?
explain, let me
Yeah.
explain. Sort of, sort of. So, starting in about 2016, God, I have been writing about this for a while. The CDC finally issued what are known as opioid prescribing guidelines, um, which have created their own controversies, which I'm not going to get into right now. But in theory, the guidelines say, and the guidelines are not mandatory, but they are, shall we say, strongly urged with a couple of sharp elbows. They strongly urge doctors to really be careful about prescribing opioids. And in fact, opioid prescriptions have dropped overall. They have. And the overdoses that you're seeing now are not, the vast majority are not related to prescription opioids. Whether they're related to fake prescription pills that you buy over the internet is another question entirely, and pills that are laced with fentanyl. But the pharmacies still they're not handing out as many prescriptions for opioids as they used to because they're not being asked for as many. That said, they still have an affirmative obligation to change their practices, because just because this generation of prescription opioids has quieted down somewhat, who's to say that the next one isn't already on the drawing boards? So what are you going to do to make sure this doesn't happen again? That's a lot of what this litigation is about. It's not only correcting the past, it's making sure it doesn't happen again.
Got it. Okay, the article, CVS, Walgreens, and Walmart must pay $650.5 million in Ohio opioids case from last week. It has a feeling of a kind of a big headline, and it is, but as Jan says, she's been covering this since 2016, and it seems this 20-year saga could easily go another 20
No, no, no,
years.
no, no,
So
no.
we'll
No, no,
we'll
no,
that
no, no, no.
you might by then have gone to law school. Don't get me wrong, but we'll look to you in the shorter term for what's going on here. And thanks very much for being with us here today.
Thanks for your time and your patience with me. Thank you.
Likewise, I'm sure.